SJC-12774, Commonwealth v. Frederick Pinney.
Mr. Thompson, still good morning.
Good morning, Chief Justice Gantz, members of the court. My name is John Thompson. With me is my partner, Linda Thompson. Together, we represent Frederick Pinney in this bail appeal, or this pretrial release appeal, I should say. We're here because of an interlocutory appeal initiated by the Commonwealth in this murder case. The interlocutory appeal has been pending, is pending in the appeals court, and it has been in litigation for a little over a year, about 13 months. Mr. Pinney has been in jail for a little over 68 months, pending trial.
What are the reasons for the delay?
There are several reasons for the delay. There was a 23-month delay before trial, mostly brought on by the Commonwealth's desire to do late DNA testing. There was an interlocutory appeal after the trial. That is, the first trial resulted in a hung jury and a mistrial due to jury misconduct, in which the jurors inappropriately discussed their deliberations with their standby jurors, and several of the jurors expressed an opinion that the defendant was not guilty. Then there has been the litigation of the motion to suppress. That is, we brought a motion to suppress the defendant's statements to the police that was successful, and now the interlocutory appeal of that matter. So the total has been 68 months, but Mr. Pinney had originally had a trial date in 2015 that was postponed at the Commonwealth's request and over his objection. Rule 15E addresses this situation specifically, and it's a special pretrial release provision that is separate from the pretrial release or bail statutes that apply in standard situations. In this situation, it is taken as given that the defendant is detained and that the defendant has won an important victory in the pretrial litigation. Before the rule went into effect, this matter was governed by Chapter 278, Section 28E, which said simply that in this situation, the defendant shall be released on personal recognizance. When the rules of criminal procedure went into effect in 1979, the provisions of Section 28E were transferred to the rules of criminal procedure, and the language on this particular provision was changed to the defendant may be released on personal recognizance. Because of that language and because of the policy that it pronounces implicitly, that provision should continue to be seen as mandatory. That is, an interlocutory appeal extends the pretrial detention of a person by 1 to 2 years. It's clear that the provision of Section 28E was saying the defendant should not have to underwrite the interlocutory appeal with loss of liberty.
Notwithstanding the use of the word may.
Now it's changed to the term may, but the term personal recognizance remains there. So the action phrase is may be released on personal recognizance.
Right, which implies discretion.
Some discretion. But the question is...
I don't get what some discretion is.
Well,
It's either discretion and no discretion. We have mays and shalls. You got a
that's
may.
right. But Since this is a question that this is an issue that deals with the individual rights of a person, that is the defendant, and it's substantive due process right to liberty. The default position, the default provision of Massachusetts law is liberty, not detention. And the simplest way to implement that in this situation is to make the term mandatory. There's no legislative history, there's nothing that changed when the provision was moved from the statute to the rule that explains why that term was changed from must to may.
So every, let's stick with murder cases. So
Yes.
every time we have a horrible murder case with potentially a horrible defendant, and I'm not saying that this case fits into either, when there's a motion that the defendant brings, which is allowed, and the Commonwealth exercises its right to seek interlocutory appeal, the price of that is not only that they have to pay the defendant's attorney's fees, but they also have to deal with the release of the defendant pending trial?
That's exactly what Section 28E provided. There's no case law interpreting that. There's no recorded situation where that created a problem. So the answer is yes, that was the law under 28E, and yes, that should be the law under Rule 15E, because the defendant's liberty is that important. It's a fundamental interest. In this situation, Mr. Pinney's situation, that conclusion is reinforced by the fact that he's been held pretrial for 68 months. In Commonwealth versus GF, where a person who was being held for a sexually dangerous persons trial for 7 years, this court found that that was a violation of substantive due process. That was under a statute which prohibited pretrial release. And this court said that that defendant was entitled to an opportunity to be released. And that meant that he was to be released unless the Commonwealth could show that he was dangerous. So in that situation, there's a presumption. That was a presumption of release based on the principle of substantive due process. That was the deprivation of liberty for that extended period of time after one mistrial. Here there's been a mistrial. There's an extended deprivation of pretrial liberty, and it's going to go on for at least another year. We're going to have a person who's detained at least as long as GF was detained.
And you say another year because the case was brought to the appeals court how long ago?
The case was entered in the appeals court. It's been briefed in the appeals court as of, I think, October or November, but it hasn't been scheduled for oral argument. And it's not unusual for...
Requested an expedited argument?
We have not requested an expedited argument. We did request an expedited proceeding in this case, but we have not requested expedited argument in the appeals court.
And why not? I mean, I know you're both very fine attorneys, so why didn't you do that?
Well, they just finished the briefing within the past couple of weeks. And right now we're focused on this. We're two attorneys and
I understand.
we have limitations. So the interpretation of this rule is an important one generally. And that is because the rule applies to all interlocutory appeals. But in Mr. Pinney's case, it's particularly important because of the unconstitutionally extended pretrial detention that's involved here. And we're requesting that the court order his release on personal recognizance now. Now, what the phrase, the term may be released on personal recognizance has to mean is it has to mean that there can be no cash bail. That is, the provision, even if it's a discretionary decision, The provision here says, may be released on personal recognizance. The focus remains on personal recognizance. This is a special pretrial release provision, both in the mandatory and the possibly discretionary version of it. The focus is still on personal recognizance, which means no cash bail. So the presumption that we're talking about here is that the defendant should be released on personal recognizance presumptively. And if that presumption is overcome, then additional conditions may be imposed that the defendant can meet without the expenditure of money, which he doesn't have. There's no question in the record that this man, he has been unemployed for 5.5 years. He doesn't have any assets. He can't pay anything. But there have additional conditions were imposed. GPS, confined to the state, home confinement, those sort of things to ensure his appearance at trial, which is the only concern here. So even if this is not a mandatory requirement, which we think it clearly should be, it has to be the conditions that are set, it has to be something that he can meet, something that he can satisfy so that he can be released. It's the only way to defend his substantive due process rights, his liberty interest here. And those, so far, in the proceedings in this case, have not been given any consideration whatsoever. Neither the Superior Court judge nor the single justice gave them any weight at all.
Okay, thank you. Mr. O'Sullivan.
Good morning, Mr. Chief Justice, and may it please the court, Shane O'Sullivan for the Commonwealth. The Commonwealth would first like to address the permissive language of Rule 15E. As laid out in the Commonwealth's brief, Rule 15E clearly uses the word may, which is generally seen as permissive. The Vasquez case citing Baker notes that from early colonial times, bail was a discretionary decision in capital cases. The statute or the rule also uses both may and shall, indicating that the words carry their ordinary meanings. And looking at Section 28E, the legislature opted to remove the mandatory release language upon appeal from Section 28E. 28E was also rewritten to conform the statute to the rules, as noted in the Gonsalves case. So the Commonwealth feels it would be illogical to read that requirement into it when the legislature explicitly chose to remove such language. The Commonwealth also said to the reporter's notes, which seemed to indicate that this decision is a discretionary one. In regards to the due process concerns the defendant raises, this court's review is limited to an abuse of discretion or other error of law. The judges both indicated in some way, shape, or form in both bail determinations that there was a strong case represented by the Commonwealth, or that they felt the case was strong. That decision is reviewed only for other such as assessment involved a clear error of judgment. The Commonwealth would suggest that there's nothing in this record to suggest such an error in judgment.
Was there the second bail determination, the reconsideration, was that Judge Wren?
I believe it was, yes, Your Honor.
He had just a couple lines. Now, Brannigan requires some statement. It's hard to say how much, but we will at some point, some statement about the financial inability to pay and how that's factored in. When Judge Wren makes his decision, which I think was just a couple of short lines, do we just look at that, or do we incorporate what was said at the first bail determination and the findings on the form that was made by, I think, Judge Ricciardi?
Well, first, in regards to Brannigan, Your Honor, I would suggest that Vasquez indicates that the Brannigan statement that's required isn't required in a first-degree murder case. Based on, as Vasquez indicates, the potential penalty and the possibility of flight are at their greatest significance in a first-degree murder case, they quote it as being a uniquely severe penalty. So given that, inherent risk of flight, Vasquez says the judge's findings need not address the defendant's ability to pay. In assessing the reasonableness of the bail number in general, I think this court could look to both determinations. And I would suggest that in looking at both determinations, both judges gave reasons which would support a high cash bail. Admittedly, the second bail judge's decision, Judge Wren's decision, which I believe was Judge Wren's decision, was less detailed.
But when he says, I guess my question is, I think he says something like this is a first-degree murder case. Do we sort of assume that means there's the inherent risk of flight that we consider when we're dealing with first-degree murder cases?
I think it does. I think that he stated that indicates that that was one of the considerations that he was relying on. And given that consideration is kind of unique compared to all the other considerations in a bail request, it puts, I would say, the level of findings on a different footing, whereas if it wasn't a first-degree murder case, then there would be an additional Brannigan finding of fact that the judge would need to make. But Vasquez, I think, clearly indicates that in a first-degree murder case, that finding is not necessary because of the inherent flight risk that exists in that type of capital case.
Should we view this any differently from a finding by the judge that I'm going to deny bail because there's no chance in God's green earth he's going to make the $250,000?
I'm sorry, like, are you asking, should we view that as a...
Should we view it as the equivalent of a denial of bail, given the practicalities of the circumstances?
I don't believe so, Your Honor, because it is inherently different. I mean, being held outright to bail, there really is no possibility. Here, the defendant does have some, albeit remote, possibility to post a bail and to be released. And in regards to the defendant's ability to pay, the first judge noted $0 ability to pay. It apparently credited the defendant's representations in that regard. However, I would also suggest there was very little evidence presented as to ability to pay in this case. And the second bail judge made no determination in that respect, as he was not required to. But I do still think there's a difference. In one, there is no possibility whatsoever. The defendant's position, I think he was given a better situation in regards to bail than was required. So there's still some practical difference, I would say. But we would acknowledge that it does seem that it's still remote. And I think the first judge's reasoning was well thought out and correct, where he stated that he still felt that the defendant was entitled to some bail, but he thought that given the nature of the case and what the Commonwealth had represented, a significant cash bail was required, and to him that meant the $250,000. The second bail judge appeared in his decision to agree with that. And those reasons articulated by the judges were permissible reasons, as consistent with Vasquez and Brannigan, to make such a determination. They cited the strength of the Commonwealth's case, the nature of the charges, and the Commonwealth would suggest that there's nothing in this record to indicate that those were abuses of discretion.
So I'll ask you the same question I asked your brother. Have you asked for the hearing to be expedited?
The Commonwealth has not asked for the hearing to be expedited. We would have no issue with the hearing being expedited. I will say that I think both parties have been very good at prioritizing the briefing in the appeals court. I know the Commonwealth, I can say, did not ask for any extensions, and I can't remember the defendant asking for any significant extensions, if they asked for any. I think most of the delay was in assembling the record and the transcripts, which the parties really had no control over. But we would have no problem with expediting the brief or the argument in the appeals court.
Okay, thank you.
Thank you, Mr. Chief Justice, and thank you to the court.